Here we go. Are you listening to me? Are you listening to me?
Good afternoon. Let me begin on a personal note. It's been my privilege to work in the office of the governor of the state of Alabama on 2 different occasions and for 2 different governors, Bob James and Bob Riley. No one in this state has more respect for the office of the governor than I do. From firsthand knowledge and experience, I can tell you that that office is the most powerful office in our state. And when used properly, it can do great things for our people. For the past 6.5 years, Bob Riley has exemplified the good that can be done with such power. I've always admired him, and I have held his accomplishments in the highest regard. I was proud to have worked for him and to call him a mentor and a friend. And I still am. What brings us here today may best be described as a situation where the right thing is being done the wrong way and with serious consequences. That right thing is to seek an answer to a legal question. Can bingo be played electronically where constitutional amendments approved by the voters allow it? The governor and I have differed over where this question should be answered. I still don't think that the kind of judicial activism that the governor seeks is best. Nevertheless, the governor has set us on a course where that is how these matters will likely be settled. That said, no crisis was required to answer these questions. Such questions are answered hundreds of times a day in an orderly way in courthouses across Alabama. No, this is a simple question that needs a simple answer. Yes or no. So far, those who favor bingo and those who oppose bingo have played loose and fast with the court decisions, seeking some public relations advantage from mischaracterizing the latest court ruling. It's time for a definitive yes or no answer to be sought and gotten. If the answer is no, we must immediately close down every bingo game in Alabama and deliver a monopoly to the Indians. Incredibly, contrary to what our citizens have been told, as of today, 416 days since the governor appointed a gambling task force, that question still has not even been put before the Alabama Supreme Court. In fact, as recently as November the 13th of 2009, the Supreme Court expressly stated that the question of the legality of electronic bingo in Alabama had not been brought before it, and therefore they were expressly declining to answer it. Don't take my word for it. Read it for yourselves. As you all know, a simple, definitive answer from the Alabama Supreme Court would become indisputable law. Law that is definite, clear, and due to be uniformly enforced. Until then, though, we will continue to struggle with the difficulties of having a mishmash of 17 different constitutional amendments in 16 different counties, and no amount of saying that the law is uniform will make it uniform. Until clarity comes, gambling operators will continue to tweak their operations to stay one step and one more lawsuit ahead of the law. It's my honor to have been practicing law in state government for 16 years. 4 years in Governor James's office, 4 years as an assistant attorney general, 2 years in Governor Riley's office, and 6 years as attorney general. In all of those 16 years, I have never seen a more ill-advised and reckless approach to a legal issue than the current approach now being undertaken by the governor's task force. Rather than moving quickly into a court of law to obtain an answer, the task force has regrettably chosen drama, intimidation, and force. Anyone who questions the appropriateness of their actions, whether by questioning the cost of these activities or the necessity of the reckless approach that has led to armed law enforcement standoffs over misdemeanor violations of state law, or by pointing to the monopoly that's being delivered to the Indian casinos throughout Alabama, is given the same response from Mr. Tyson, the governor, and their spokesman, that they are simply enforcing the rule of law. I submit to you today that there are other rules of law that are just as important and that are being ignored today, such as equal enforcement of the law, equal protection under the law, and due process of the law. Pointing out that these laws are also important and that they are due to be respected does not place one on the side of the pro-bingo debate, but rather on the side of the Constitution. After all, those who wrote the Constitution and its amendments, men like Thomas Jefferson and Alexander Hamilton, didn't have a side in a bingo dispute when they wrote these ideals into our United States Constitution, its Bill of Rights, and its amendments. Instead, they had in mind putting some of America's most prized liberties into words and into a document from which these principles would still be protecting us over 2 centuries later. Without understanding that all of these ideals work together to make a single rule of law that protects all of us from government, the rule of law becomes less of a process and more of a weapon that serves political agendas as might makes right. That's not the nature of our system, of our state, or of our citizens. State law clearly establishes the Attorney General as the state's chief law officer, and the Supreme Court has affirmed this to be the case on many occasions. It's within the authority of the Office of the Attorney General to intervene into the controversial and irresponsible activities of the task force and to direct Mr. Tyson's actions. Frankly, that's an option I have strongly considered over the course of the past 2 weeks. The task force's pending armed confrontation with Greene County authorities left me no choice but to consider this option. It is beyond comprehension that we now find ourselves in a position where armed law enforcement in Greene County may soon be confronted by armed state troopers, all in the name of the rule of law. This situation was unnecessary, and it cannot be tolerated. The safety of law enforcement officers and even the general public cannot be so recklessly put at risk. Yet, out of deferential respect for the governor, assuming direction over Mr. Tyson is not an option that I'm prepared to exercise. Yet, I will not question the governor's intentions or his motivations. I've made it clear that I will not engage in the empty, counterproductive rhetoric surrounding this issue, and I intend to keep it that way. I invite the governor to rejoin me on a higher level from which we can implement a solution to this problem that does not demean the process. Regardless of the personal attacks that may have to be endured to perform my constitutional and statutory obligations as Attorney General, I am duty-bound to inform the governor when it is the legal opinion of this office and of my lawyers that his actions are questionable or potentially expose our state to devastating liability, even if he doesn't want to hear it, perhaps especially when he doesn't want to hear it. I have offered this advice in general terms on several occasions. It's gone unheeded. Perhaps that's because my advice to this point has been general. Today, I seek to correct that. As a friend, as a lawyer, as a former legal advisor to Governor Riley, and as Attorney General, I remind the governor today that the rule of law is more than mere words, and certainly more than a catchphrase which, when repeated, can justify any action. It's a process, the very foundation upon which fair and orderly government depends. It's not too late for the task force to correct its ill-advised and dangerous course. I am therefore advising the governor. I am imploring the governor to immediately implement the following specific, responsible 3-step plan.